This is Good Morning Nigeria, and as a prompt for our conversation on constitutional amendment, here's our correspondent Oyeyemi Ajayi with a background report.
The year 1999 will continue to be described as a watershed in Nigerian politics and democracy, not just for the smooth transition from the military rule to democratic system of government, which has been sustained till date, but when the country's present national constitution was drafted. Since then, the country has been guided by the imprints of the national document to be respected by all. However, over the years, there has been a clamor from various quarters for amendment of the Constitution, backed with claims that some of the laws inherent in the Constitution are not consistent with modern trends or do not guarantee equality and justice in the Nigerian Federation. Some punishments and fines, for instance, were pointed out as not being commensurate with the offense, encouraging offenders to go ahead with the offense and pay the fines from the breast pockets. The two chambers of the National Assembly have since set in motion a joint committee on the review of the 1999 Constitution with issues bordering on local government administration and autonomy, the legislature, judicial reform, state creation, state police, devolution of powers, women and vulnerable groups, strengthening of the institutions, good governance, political parties and electoral matters, fundamental human rights and national security. Part of the issues being considered by the National Assembly's Joint Committee on the Review of the 1999 Constitution is to split the state joint local government accounts created under Section 162, subsection 6 of the 1999 Constitution to grant full financial autonomy to the third tier of government. The Deputy Senate President Ovie Omoagege, who chairs the Joint Senate and House of Representatives Review Committees, has urged lawmakers in the 6 geopolitical zones to ensure that the ongoing proposed amendments is done in the interest of Nigerians and not personal interest, adding that the review will be ready by the end of February. He reviews the consultants have recommended over 55 bills from hearing and memoranda submitted by the public. Now, how progressive is the ongoing constitutional review and amendment process, and how beneficial will it be in advancing the Nigerian Federation? These are issues that will engage guests on the program soon.
All right, joining us to discuss this topic and from our Jos Network Center is Professor Dakas, C.J. Dakas, Senior Advocate of Nigeria and a consultant to the National Assembly Constitution Review Committee. He is also a former Attorney General and Commissioner for Justice in Plateau State. Professor Dakas, it's our delight to have you on Good Morning Nigeria.
Thank you very much. Good morning, Nigeria.
All right, Prof, walk us through the efforts so far undertaken at making a fifth alteration to the 1999 Constitution. We understand that most likely by the end of this month, the final report of the Joint Committee of the Senate and the House will be made available, and you've been a consultant. Has this been a rigorous process, or it's just been seeking to pick and choose which of the issues are convenient?
Thank you very much. First, I think as the background report pointed out, the Nigerian Constitution emerged in circumstances that were transitionary, in the sense that we were moving from the military government to a civilian government in 1999. And given the context in which the Constitution emerged, you can understand why there have been a number of challenges. Quite a number of Nigerians have expressed the view that the Nigerian Constitution, in spite of the fact that it proclaims to have been made by we the people, is actually not made by the Nigerian people in a manner in which there was genuine engagement with the Nigerians in terms of what they wanted. And that's where you'll find a great deal of debate about the subject of devolution and a whole range of issues. Now, Section 9 of the Nigerian Constitution sets out the framework for the amendment of the Constitution. And what has happened thus far is that each chamber of the National Assembly has constituted a special committee on constitution review. And as part of the work that has been undertaken thus far, a number of bills have been introduced before the National Assembly, but these bills have also thankfully been the product of engagement with the Nigerian people. For instance, what the National Assembly decided to do was to devolve and evolve mechanisms through which to harvest the views of Nigerians. And so, for instance, a number of public hearings were held in different parts of the country, and that gives you a sense of how rigorous and engaging the process was. But in order to make sure that both chambers of the National Assembly are on the same page, they decided to have joint retreats so that they would have the opportunity not only to engage with each other, in other words, each chamber of the National Assembly, but also recently, indeed just over the weekend, there was an opportunity to engage with speakers of the state houses of assembly. As many Nigerians probably know, the constitutional process for amendment under Section 9 requires not only the engagement of both chambers of the National Assembly, engagements with Nigerians, but also even where the National Assembly passes a bill for an alteration or amendment of the Constitution, it eventually goes to the states, and you need 2/3 of the states, in other words, 24, for any proposal to pass. And that's why the National Assembly deserves commendation, because it has not only engaged Nigerians, but it has also engaged the speakers of the state houses of assembly. And the idea is that at the end of the day, we will all be on the same page so that we can move the process forward.
Okay, during the engagement process of getting Nigerians to be part of the process itself of the amendment of the Constitution, what were the issues overriding national interest and concerns raised by Nigerians?
Let me start with one of the proposals that I believe is groundbreaking, and I hope that this is a proposal that will be taken extremely seriously. And this has to do with the place of women in governance. When you look at countries like Rwanda, even Uganda, and a number of other countries, I'm not even talking about the United States, I'm not even talking about Europe, I'm talking about African countries, you will find that the place of women in governance is a very perilous one. Women are not having the opportunity to be adequately represented in governance. And one of the groundbreaking proposals that I pointed out, that I believe will be a watershed if it passes, is the proposal to create special seats for women in the legislative arm of government. For instance, this proposal would require that every state will have one seat reserved for women in the Senate. At the level of the House of Representatives, every state will have 2 seats reserved for women. And at the level of the State House of Assembly, each senatorial district, and you will recall that there are 3 senatorial districts in every state, each of these senatorial districts will have a seat reserved for women. Now, what is interesting is that at the moment, when you take the composition of the Nigerian Senate, each state has 3 senators. What it means is that there will be 3 senators, but there is an additional seat for women, so every state will produce 4 senators. And the fact that there is a seat reserved for women in every state in relation to the Senate does not prevent women from contesting for the other 3 seats in relation to the existing seats in each state for the Senate, for instance. And this is intended to address, as I said, the gross underrepresentation of women in governance. And I hope that this is a proposal that will be taken extremely seriously. And just like we had the not too young to run bill, as one of the signature accomplishments of the 8th National Assembly, we will hopefully have this proposal as one of the signature accomplishments of the 9th National Assembly. Also, there is a proposal that addresses the subject of local governments. If you look at the state of our local governments, this is the level of governance that is closest to the people. Unfortunately, you find that to a large extent, many of these local governments are not able to perform their functions effectively. And part of the challenge is because of what is called the state joint local government account. In quite a number of states, it's not in every state, but in quite a number of states, you find undue interference not only in the operations of the local governments, but in terms of their funding. And one of the proposals in the context of the ongoing constitutional review is actually to abrogate the state joint local government account and to create accounts for the local governments where there will be direct payment of whatever is due to the local governments from the federation account. But I would hope that within this framework is also an accountability mechanism so that the money that goes directly to the local governments does not also end up in corrupt hands. Another proposal relates to the subject of the autonomy of the state legislature and the autonomy of the judiciary. Nigerians will recall that as recently as on Friday, I believe, the Supreme Court came to the conclusion that Executive Order number 10 that Mr. President had signed was unconstitutional. Now, Executive Order 10 is the order that sought to implement the autonomy of the state legislature and the state judiciary. And in the face of the decision of the Supreme Court, it now becomes extremely critical that the proposal that is on the table now for the autonomy of the state legislature and the state judiciary is one that will also be taken extremely seriously. But let me just draw attention to one other thing. One of the agitations of Nigerians is the devolution of powers. And this is born out of the fact that even though we have a federal structure, this is, in the views of many scholars and in the views of many commentators, skewed in favor of the federal government to the detriment of the states. And there are proposals to devolve some of the items that are on the exclusive list to the concurrent list. And I hope again that these are issues that will be taken extremely seriously so that we have a federal system that works for Nigerians.
Professor Dakas, thank you very much for the insights you have provided into some of the proposals for amending the Constitution for a 5th time. I would like you to go over again the proposal for positive affirmative action for women. You were talking about each state now reserving a seat for women. And what is it for the House of Representatives, and what is it for the state houses of assembly? And is the Federal Capital Territory also captured in this?
Yes. As I said earlier, at the moment, there's an equality of states when it comes to the Senate. So each state has 3 senators. The FCT has 1 seat, and that makes up for a total of 109. Now, under this proposal, each state will reserve 1 seat for women. So we will now have 4 senatorial districts per state. And only women will be eligible to contest for the 1 seat that has been reserved for women in respect of the Senate. But it will not prevent women from contesting for any of the 3 seats. Now, when it comes to the House of Representatives, each state will reserve 2 seats for women. At the moment, we have 360 members of the House of Representatives, and we will now have 2 per state, And then you will also have representation at the federal capital reserved for women. And then at the state level, every state house of assembly will now have an additional 3 per state, because each of the senatorial districts will produce 1 woman. Now, let me emphasize this. As you pointed out, this is an affirmative action initiative. And affirmative action essentially is a special purpose vehicle that is intended to be a remedial measure to address a particular concern. And I like to emphasize this because a number of people have said, oh, if you reserve special seats for women, then it means that that constitutes reverse discrimination against men. I do not think that that argument is right. It is a special, whether or not we like it, women, for no fault of theirs, have not been given the opportunity to be adequately represented in governance. Sometimes when you look at the plight of Nigerian women, it is as though the fact of being a woman inscribes a disability on your forehead. And I think that we need to address that challenge. And it is certainly, in my respectful view, not fair for people to then say that that constitutes reverse discrimination. Even in international human rights instruments, if you look at the United Nations Convention that addresses discrimination against women, you'll find that there is an affirmative action clause. So this is a global best practice, that when you have a specific challenge, then you need a special purpose vehicle as a remedial measure to address that challenge. There are also a number of commentators that have raised opposition to this proposal, and they predicate their opposition on the cost of governance. Now, the cost of governance certainly is a major challenge that we need to address. But you need to situate this in a broader context that looks at the ultimate objective that is sought to be achieved. We need to have the voices of women on the table. When you look at the statistics as it regards Nigeria's census, there is almost an equal number of Nigerians, male and female. And when you have a system where you are essentially tying the hands of about half of your population, and you are not giving that half the opportunity to contribute its own quota to the development of the country, then I do not see how that country can make progress. And so I would like Nigerians to look at these in a broader context and look at it as a special remedial measure, so that we're able to have the voices of Nigerian women and their contributions on the table, and consistent with global best practice, to then engender and institutionalize this regime of affirmative action in order to move the agenda forward. And I think that this is the context within which this needs to be appreciated.
Professor Dakas, thanks. So let's look at the cost implication argument of this proposal. If you have an extra Senate seat for women, that would mean that at the Senate you will have at least 144 members. And if you have another extra seat for women in the FCT, you will then have 145 senators. Now, for the House of Representatives, if it is 2 per state, that means you have 72 additional members in the House of Reps. That would be 432. And if you added 1 extra in the Federal Capital Territory, that will give you 433. Now, at a time that Nigerians are talking about the high cost of governance, the larger objective of seeking to have a place for women participate in governance would appear to be trumped. I'm sure you know that every day it's an issue as to how the National Assembly is funded, as to how the cost of maintaining 1 senator in this country is a huge leakage on our public wallets, along, of course, with the House of Reps. And there are many more things that you could use resources for rather than ballooning the number. Plus, the pre-existing argument, Prof, to which I would like you to respond to, which has come up from time to time, that why don't you even reduce the size of the 2 chambers, or alternatively have a unicameral legislature?
Thank you very much. As I alluded to earlier, the cost of governance certainly is a major challenge that we need to engage. But in the context of this Constitution amendment exercise, I'd like to draw attention to the fact that one of the facilitators of this process is actually an NGO called PLAC that has been very engaged in facilitating this process. And in the course of our deliberations, because we had very robust engagements, and we decided through PLAC to do a cost-benefit analysis to address the argument about the cost of governance. And that report clearly shows that at the end of the day, it's a net positive if you create these special seats for women, even when you factor in the cost of governance argument. Second, I have myself written very profoundly about the need to reduce the cost of governance. And one of the ways through which we can reduce the cost of governance, as you rightly pointed out, is some of the proposals that are on the table. But let me deal with, if you look at the cost of governance relative to the executive and the legislative arm of government, you will find that the cost of governance balloons, to use your words, a lot more at the level of the executive. And there's a great deal of waste at that level than even at the level of the legislative arm of government. In terms of the proposal, for instance, to have a unicameral legislature, what we need to appreciate is the fact that there is a context that explains our bicameral legislature at the national level. Our bicameral legislature draws from the American experience. There is what in the American experience is called the Great Compromise. They were confronted in the context of the American experience with a situation where big states like California, like New York, like Texas, and if you say it, you are going to have an equal number of senators, for instance. It would mean that the big states and the smaller states would have an equal representation in the United States Congress, for instance. But if you now said it was simply going to be proportionate representation, you are going to give more leverage to the bigger states at the expense of the smaller states. And what was called the Great Compromise was this solution of a bicameral legislature, so that in the Senate, as is the case in the United States, you will have an equal number when it comes to the Senate, irrespective of size, irrespective of population. But then when it comes, and then you will then have responded to the plight of the smaller states. But in order to respond to the concerns of the big states, you now have proportionate representation in the House of Representatives. I would argue that if you want to reduce the number, especially in view of the proposal for special seats for women, I would argue, for instance, then perhaps what you need to do is, instead of the existing 3 seats, senatorial districts per state, why don't you then reduce that number and still create a special seat for women in order to address the overarching objective of greater participation of women in governance? So those who argue that special seats for women then increases the cost of governance can then say, all right, are we prepared to make the sacrifice, and then say we reduce the number, and you can say, for instance, as is the case in the United States, where you have every state, the 50 states in the United States, have 2 senators. So why don't we say, for instance, that if we're genuinely interested in saving costs and also addressing the challenge of women greater representation in governance, why don't we then say, all right, every state, you produce 2 senators, one of them, at least one of them must be a woman. Then we know that you are serious about ensuring that you mainstream gender into governance in our country.
I sort of totally agree with your last statement, to mainstream it and, come at par with other countries of the world. Because as a woman, I still feel that creating a special seat for women, it's sort of, there's still tag that women were not able to do the job. As women, you should be given the opportunity to go out there and slug it out. women should be given more opportunities to try as much as possible to reach out, because at the onset of Nigeria's democracy, women were there. They were at the forefront of the campaigns. Why should women be used in campaigning for men to get to office and they cannot get that office? That is one thing I seriously do not agree with, creating special seats. I believe that these seats, if it's 3 seats like it's in Borno, 1 should go to a woman, instead of creating another additional seat and spending more money in that office. I still think that that aspect of the constitutional amendment needs to be looked into critically. Let's now move on into the strengthening of the legislature in the states, where so much power lies with the governors.
Juma, if you don't mind, so you're moving on, which means probably we're leaving the subject
No,
matter.
we're not leaving the subject matter.
Yes. No, subject matter of affirmative action.
Yes.
Because I wanted Professor Dakas to probably give us a preview of how the provisions for amendment may have been drafted as follows. When you say, assuming this provision stands, yes, for proposal to say, look, 1 seat is reserved for women, how will that woman victor emerge in the conduct of elections? Because on the day you are having your National Assembly election, if you say 3 senatorial districts, they will slug it out in those 3 senatorial districts. For the 1 woman senator that is going to emerge, will it be like a governorship election that you say, look, the entire state is your constituency? What are the draft provisions for this amendment?
Very much. That's an extremely important point. When it relates to the Senate, when you're having the senatorial elections in respect of the 3 existing senatorial districts, the elections will be conducted in the relevant senatorial district. But for the special seat reserved for women, it now becomes a statewide constituency. And so when the elections are being conducted for Senate, it would mean that for that special seat that is reserved, it will be a statewide election. It's just like from our previous experience, you have National Assembly elections and presidential elections on the same day. So just like in your senatorial district, you will be voting for the senator for that senatorial district, and then you will also be voting for the House of Representatives for the federal constituency concerned, and then you will be voting for the presidential elections. When it comes to the special seat for women, because it's a statewide office, it means that while you are at your senatorial district voting, you will now be voting for that statewide seat at the same time.
Okay, that's okay. Like I said earlier on, you've made a point there, and I believe women now have, the push to be able to seek for office and be part of governance in Nigeria. I'm talking about strengthening the House of Assembly, despite the striking out of the Executive Order 10 by the Supreme Court, and so much power being in the hands of one person, that is the governor of the state, where they decide what the local government does, they decide what the legislature does. How can the devolution of power be able to ascertain the fact that the legislature in the states need to have autonomy and independence for them to be able to function effectively?
Thank you very much. Under the proposed alteration or amendment, the legislature then becomes a lot more autonomous and strengthened. Now, what is being proposed is that any amount that is due to a particular state in what is called the Consolidated Revenue Fund of the state, and that's the fund from which you draw the budget. Now, if there's any amount that is due to the State House of Assembly, for instance, that amount will be released directly to the Assembly. And the proposal makes provision for what is called a disbursement committee. And that disbursement committee addresses the subject of financial autonomy, not only of the legislative arm of government, but also of the state judiciary. So when you look at the proposal, you will find that the disbursement committee has provision for a composition that includes, for instance, the clerk of the House of Assembly, the people in finance in the House of Assembly, the chief registrars of the courts, so that is the framework within which funds that accrue to the judiciary and to the legislature are disbursed. And unlike under the current arrangement, where each time the legislative arm or the judicial arm needs to expend resources, it has to now apply to the governor for approval. There is a framework within which what is due to each of these arms will be given to them in the appropriate installments. And where you discover, for instance, that in a particular month there is a shortfall, and subsequently you now have a lot more resources, there is a framework within which you go back and address the shortfall in the previous month. Now, this is intended to strengthen the legislature and the executive, and the judiciary at the state level. But I would like to also emphasize that when these other arms of government at the state level are strengthened, they need to exercise the power that the Constitution reposes in them with a great deal of responsibility. Because if they don't do so, many governors will be apprehensive. And the reality is that power often corrupts, and absolute power corrupts absolutely. I would say that power intoxicates, and absolute power intoxicates absolutely. And so if governors, for instance, are apprehensive that the financial autonomy of the state legislature, for instance, will then lead to a resurgence in the number of impeachments, then that also becomes problematic. And within that context, let me also draw attention to one of the proposals that I think is also important. And this relates to qualified immunity. Under the proposal, you would note that under the current constitutional regime, I think under Section 308 or so, the president, the vice president, the governor, and the deputy governor have absolute immunity from criminal and civil processes until after the expiration of their tenure. Under the current proposal, provision is being made for qualified immunity. And under qualified immunity, if, for instance, any of the beneficiaries of the immunity clause is alleged to have engaged in corrupt enrichment, or is alleged to have committed an electoral offense, or is alleged to have disobeyed a court order, under these 3 or 4 categories, there is a proposal that immunity will not avail the beneficiaries of the office. Now, I raise this also in the context of the autonomy of the legislature, because, again, if this is not managed properly, then you then find that governors become apprehensive, the president and the vice president become apprehensive. But there is a safety valve under the proposed alteration that relates to qualified immunity. There is a requirement that the prosecutor must first of all seek leave from the courts. In other words, a court will be able to take a look at what is called the proof of evidence and make a determination as to whether a prima facie case has been established as to justify the prosecution of the beneficiary of immunity. And again, this is intended to engender greater accountability in our politics. And I hope again that this is a proposal that needs to be taken seriously, dispassionately considered in the larger interest of the Nigerian people.
Well, Professor Dakas, thank you very much for the explanations that you have proffered. But just before we bring in our next guest, Ezenwa Nwango, who is Chairman Partners for Electoral Reforms and co-convener Said No Campaign Nigeria, regular guest on Good Morning Nigeria. Ezenwa, pleasure to have you with us on the program this morning. I would like Prof to respond to this issue, because earlier on, you spoke to it, so we're taking some steps back to probably just consider this issue before we move on. You did say that part of the rationale for the amendment to the Constitution, this is the 5th attempt, derives from the fact that, all right, the preambular paragraph that says "we the people" isn't quite right, because Nigerians did not participate in the making of the 1999 Constitution. That's an argument that I've heard in recent years, usually from civil society quarters. I sometimes believe that that is an unfair comment and even assessment of the efforts of General Abdulsalami Abubakar, who took over from the regime of Sani Abacha following Sani Abacha's death, excuse me, to usher in the Fourth Republic in 1999. So when you say that "we the people" as a preambular phrase is fraudulent, and the reference often, of course, is to the U.S. Constitution that says "we the people." The question I also ask myself is, how many black persons participated in the framing of the U.S. Constitution at a time when blacks were regarded as 60% human, that's 3/5 of a human being? How many Hispanics participated in the framing of the U.S. Constitution? I'm sorry, I'm not becoming a guest, but for those of us, who were around at the time, we knew the processes. They took into cognizance the pre-existing 1979 Constitution, and Abacha himself had convened a constitutional conference, even though there were claims in some quarters that they sent their second 11 from 1994 to 1995. So there was a draft constitution. And some of those elements are in our constitution up to today. The 6 geopolitical zones, for instance, proposed by Alex Ekwebe, who was a member of that conference. 30% derivation was also there, plus the various debates and publications that took place around the country and views collated, and then the draft was produced, passed, and then we had the Fourth Republic. So why do we keep saying, this is for historical purposes, that "we the people" is a fraudulent phrase as a preamble to the 1999 Constitution?
Thank you very much. That's a very important point you have raised, but I didn't say it's a fraudulent phrase. What I said was that the phrase "we the people" does not, if you look at that phrase, it says "we the people of the Federal Republic of Nigeria have enacted and given to ourselves the Constitution." But that's not true. That is not to take away from whatever General Abdulsalami did. He set up the Constitution Coordinating Debate Committee. That's what that committee was called. It was a Constitution Coordinating Debating Committee that was under the chairmanship of the late Justice Nicky Tobe. And if you step back to the context in which the 1979 Constitution emerged, the Constitution Drafting Committee, take that example for instance. When we had the Constitution Drafting Committee in 1979, it was a committee of 50 wise men. There was not a single woman in that committee that drafted the 1979 Constitution. And then we moved to the Constituent Assembly. And again, you didn't have sufficient female representation in the Constituent Assembly. And if you look at the Abacha 1989 Constitution that was aborted, and you move over to the 1999 Constitution, you will find that when it comes to inclusivity, when it comes to participation that is rigorous and engaged, you will find that the vast majority of Nigerians were not given the opportunity to do so. And let me also say this very quickly. My preference as an individual is that in the context of constitutional amendment, we should actually make provision for a referendum. What we have in the 1999 Constitution in Section 9, in my view, is not even sufficient to address the challenge of a fundamental and holistic review of the Constitution that responds to the interests of Nigerians. So my point is not so much that there was no consultation, but was this inclusive? Was this rigorous? Was this thorough? And did it address fundamental? Why are we continuing to have issues about restructuring, for instance? Why do you think that that is a recurrent theme in political and legal discourse in this country? And so I would hope that when we say that this Constitution was made by we the people, and you are articulating that argument from a legitimacy point of view, I believe that we can do much better from the point of view of participation, of inclusion, and indeed, if we had all these rigorous ingredients, it may well be that we will not even be having this conversation today about special seats for women, because some of these fundamental imperatives would have been addressed earlier than now.
Thank you so much, Prof, for your support for women. You know, it sort of gladdens my heart. It's a fact. It gladdens my heart that there's somebody out there who has so much concern for women and, you know, bringing women to the table to be able to negotiate and be at par with their male counterpart. Let me bring now Ezenwa Nwago, Chairman Partners for Electoral Reforms and co-convener, Say No Campaign Nigeria. Let's have your concerns on the, you know, topic that is on the lips of everybody in Nigeria, and that's the constitutional review. And it's been thrown open to the states too. What are your concerns? Why will we visit the constitutional review again?
My apologies first for coming in late. I think my quick sense is that a pattern has emerged where we have a constitutional amendment industry in our country. So every legislative year, we must have to. And nobody seems to be bothered about why we cannot perhaps have a holistic engagement with constitutional amendment in a way. Because when you talk about all this, how much have we ever interrogated how much it cost us to do these amendments each of this legislative year? And the consultants, all the people that play in that industry, we need to take very decisive action around the issue of what we do with our constitution. It cannot be that every legislative year you have the deputy senate president, you have the deputy speaker become chairman, and all of that. Then we go around states, and then the real issues, the fundamental issues that we need to engage, like the inclusivity issues. It's not so much, Kingsley, about the people who amended, who gave us the night. They are not from Mars. They are Nigerian people. Okay, so it's about much more, like Professor Daka has talked about, how inclusive. And that is why you have to rework the Constitution. But it cannot become a ritual that every time you are doing constitutional amendments. So I have that's my major concern. Because whether it's the issue of fiscal federalism, whether it's the issue of derivation, whether it's the issue of immunity clause, all of these issues have been with us since we've been doing this constitutional amendment, and we have not been able to have the courage to deal with them. And that is because we politicize constitutional amendment. If you take the issue of restructuring, for instance, those who are in power don't want to restructure. Those who are out of power want to restructure because they are not there yet. And so that pool, that constant engagement with whether it is for the public good, are we doing this for public good, or we are holding to our side, is the big challenge of our constitutional amendment. That's my first concern, because I don't see what is rocket science about dealing with the issue of, for instance, local government autonomy, judicial autonomy, legislative autonomy. These issues are issues that confront us, that for years we do not have democratically elected local governments on account of the fact that the governors have held that area in a way that even makes those who play in it not want the independence themselves. It's a challenge. So
why do you think so?
We have had the occasions where even the chairman, unelected chairman themselves, are coming, addressing the press and saying they don't want autonomy. It's happened in our very eye. And so if you go back to the process of constitutional amendment and you go to the states, go for public hearing, and the people who represent the people there say we don't want autonomy, you are helpless. You become very helpless. So the National Assembly, the real mobilization that has to happen for us to get through some of this is what I think I heard Professor Daka talking about. Let us mobilize the citizens to be part of the constitutional amendment process so that we take it away from those who have made it an industry. And that's my challenge.
SN1, I would like Professor Dakas to respond to your claim of the industrialization of the constitutional amendment process.
Well, I don't know whether I would use the word in the exercise becoming an industry, but Ezenwa makes a very valid point. We must not make this simply a ritual. We must ensure that the constitutional amendment exercise is also not an opportunity for money to go down the drain. I give you an example. There are a number of constitutional amendment exercises in the past that sadly, were just a waste of money. If you take the so-called third term stalemate, a lot of work had been done, and then on the subject of third term alone, the entire exercise went down the drain. I give you another example. There was another process where there was a debate as to which arm of the National Assembly was superior, because in the course of one of the exercises, and this was, I don't know whether it was the 6th or the 5th Assembly, I'm not sure now, and the question was whether you are going to have the chairman and the deputy chairman. In other words, whether the deputy speaker of the Senate was going to be the chairman and the deputy speaker of the House of Representatives was going to be the deputy chairman. And over that question, the entire exercise went down the drain. Eventually, there was a compromise, and you now have the deputy Senate president now serving as a co-chair, and the deputy speaker of the House of Representatives serving as a co-chair as well. And so you will find that, unfortunately, if this becomes simply a ritual and money goes down the drain, then it will not achieve the desired goal. I think what is important is, first of all, to acknowledge that there is a challenge with our Constitution. And let us focus on the overarching objective, so that at the end of the day, after all the money that has been spent, after all the, not only the resources, but also the time, that at the end of the day, we will put our personal interest not over and above the overriding interest of the Nigerian state. So I agree with Ezenwa that it shouldn't simply be an annual ritual, but I think, to the credit of the National Assembly, until I think the 7th Assembly, all the previous attempts at constitutional amendment from 1999 were unsuccessful. And until we had the first alteration, I think, under the 7th Assembly, and then we had some other strides under the 8th Assembly. And my expectation is that some of the groundbreaking proposals that have been put on the table will be passed. On the subject of devolution, for instance, airports is one of the items that is being proposed to be moved to the concurrent list. Correctional services, previously known as prisons, was one of the items to be moved. There was a robust conversation about whether police should be moved to the concurrent list, and that was ultimately defeated, partly because of apprehension that it will be abused. Now, my own argument, I don't have the time to make that argument here, but at least I think that this is one of the times when at least about 5 or so items are being proposed to be moved from the exclusive list to the concurrent list. And I would hope that we will eventually have a comprehensive constitution amendment exercise so that it doesn't become the ritual, year in ritual that Ezenwa alluded to.
I'm just wondering, Professor Dakas, could you lead us into some of the 5 items, if you remember them, that are being proposed from the exclusive list to go over to the concurrent list? I know you talked about prisons. That's one item. Did you say airports or aviation or something?
There's a proposal for airports, not the whole subject of aviation, but just airports will move to the concurrent list under this proposal. The second item that would move is correctional services, otherwise known as prisons. The third that I recall is fingerprints. databases in that respect. For instance, and we gave this example in the course of our interaction. If you take Lagos, for instance, Ekiti State, for instance, that have a database for serial or sexual convicts, you don't need to wait for the federal government to enact legislation on that matter. Lagos State or Ekiti State should be able to have a database where you will have fingerprints of these convicts. So fingerprints and the other items associated with that has also been proposed to be moved. The fourth item that I recall, apart from airports, correctional services, fingerprints, and related matters, I think is the subject of labor. And let me also emphasize this. What is being proposed, and I would emphasize this because I have seen a number of media reports, labor saying there's going to be a showdown. My recollection is that labor will now move to the concurrent list so that states will be at liberty to legislate on matters that relate to labor. However, the subject of a national minimum wage will remain a matter on the exclusive list. So I think that point is extremely important. It will remain on the exclusive list, the subject of the national minimum wage, so that only the National Assembly can prescribe a national minimum wage, which is the threshold. If a state wants to give more than what is prescribed, that will be fine. But I do not think that it will be fair for a state to have the liberty to now give more than what is a national minimum. That's the fourth item that I recall. There is also, I think, the subject of geological surveys. There was some discussion about that. But I think these were about the 4 or 5 issues that are being proposed to be moved to the concurrent list, so that both the National Assembly and state houses of assembly will have legislative competence over those matters.
That's quite interesting. Let me come back to Ezenwa. Part of the exclusive list is the renewed agitation for states to be empowered to establish their own police outfits. Is it gathering momentum? Is there support for it in the Constitution, and why?
The big challenge for us always is that, and I was excited when Kingsley talked about us always wanting to reinvent. There's a plethora of debates. The 2014 National Conference, of which I was a member, has a position on state police. And that was also a debate where Nigerians had debated that a big country like Nigeria shouldn't ordinarily have one central command like we have it now. The challenge is that every time we are confronted with the question of abuse of something, we outsource it. So confronting it is our issue. How do you confront an abuse? Oh, the governors will take it over. They would look at what is already happening in some states with the paramilitary stuff that they are setting up in those states. But the fear of an abuse is not enough for you not to confront the challenge that you face. That is obvious. So what are the mechanisms? I think that is where the debate should extend to. What are the mechanisms that need to happen for us to have state policing? Now, that conversation is not happening. What is, as to whether we need it, I don't think there's anybody who has not come to understand that this centralized unitarist policing cannot work. That is not going to help us.
You know, I mean, some of us also have our views on some of these issues. When there is the fear of abuse of state police, what is not being addressed, as you said, would be fine. How do you deal with that potential abuse or actual abuse when it occurs? What could be the relationship, therefore, between the federal policing authorities and the state policing authorities? And if there are instances of abuse, how do you immediately correct such abuses and then deal with the individuals who perpetrated such abuse?
So that's the mechanics that I talked about. It's not, it's the debate about whether we need a state police. I think we are moving away from that. What I hear is about the fear. And I'm saying we had an issue of drug, scaling, upscaling drug abuse, tramadol and the rest of them. There are other drugs as well that have, so people abuse those drugs. So what do? You make it that it has to now be prescription drugs. You don't go on over the counter. So you don't say because people abuse those drugs and then you say no, we criminalize. The challenge, and it's not just with state policing. Like I said, we are always outsourcing the challenges that we face. Until we come to that point where we say, how do we constitute the police, the state police service, if that is what the name would be, State Police Service Commission? Who will make that up? What will be the power of the governor over that process? We will think through all of those.
Their training, their equipment, their
armories and all of that. What is the level of control? Will there be media, civil society, professional groups, as part of that control mechanism that can help us have the desire that we have? And then we cannot say because we don't want to confront an abuse, then we don't start. We have to also learn. There are many places that we have learned from. The abuses that you fear for state police, they are already present in the federal. And you are dealing with them in one way or the other. Because the control of the police is not majorly about government. It's about the dominant forces in a place, for instance. It doesn't necessarily mean that government controls the police. If I live in my estate, for instance, and I am the one who supplies torchlights, rain boots, raincoats to the police station that is around my place. If I have personal issues with you, I control the police in that place at that point in time. Because once I invite them, everybody will say, the Oga way they bring this thing. So the other person, nobody even wants to hear him at that point. So the issue of control is important. Who controls this state police? And the mechanism for that is to think through the processes that you can put in place to mitigate those,
which we are not doing currently.
That is what the debate is not about. The debate is still about whether we want north-south.
It's nomenclature.
Yeah, it's the south wants, the north does not want. And that the national conference proved that is not true. Because at the end of the day, everybody, the consensus became that state police is necessary. And it's about mechanism.
Okay, Ezenwa, thank you. As the program begins to wind down, we'll touch on other topics, but right now we need to take a break. When we return, our conversation continues. Don't go away.
You're welcome back, and it's still Good Morning Nigeria, and we're live on the network service of Africa's largest television network, the Nigerian Television Authority. We still have our two guests, Ezenwa and Wago, with us here in the Abuja studios, and Professor Dakas, who is with us from our Jos Network Center. Senior Advocate Professor Dakas, that's an issue where you talked about earlier, attempts at ensuring that the mismanaged local government and state joint accounts don't get to be so. And then the question arises as to what we have seen, despite Supreme Court pronouncement on this matter, namely the existing Section 7 of the Constitution, which provides for democratically elected local governments. What we have all around are caretaker committees in a number of the states. And in some cases, when elections get to be conducted by the state independent electoral commissions, they are, in most cases, again, almost a sham. Are there provisions to deal with this in the event that a state doesn't have local governments that have been democratically elected in the true sense of it?
That's another very critical component of the constitutional amendment proposal that is under consideration. But if I may, let me just make a few comments very briefly on this subject of state police. And I share the views that have been expressed by some Nigerians, including Ezenwa, that we need to put in place mechanisms. We should focus on the kinds of mechanisms that need to be put in place in order to ensure that there is no abuse. But the other point is that we need to also ensure that with the state police comes a great deal of responsibility. Part of the challenge that we have in quite a number of states is that they're not even paying the salaries of their personnel at the moment. And it means that they must also ensure that they take responsibility for the equipment, for the personnel, for the barracks, and so that we do not have a situation where you have state police, which for me is desirable in any event, but then you have a situation where you now arm the state police, and then you are in default of the payment of their salaries. And so you are essentially having armed people that do not have salaries, and they become a monster. So that's part of the conversation that needs to take place. But as I said, my own preference is that we need to devolve policing to the concurrent list, but we must be mindful of what the challenges are so that we can consciously work towards addressing those challenges. Now, let me come very quickly to the issue that you have raised. I had addressed the subject of the financial autonomy of the local governments, but you have now raised the very critical component of the administrative structure of the local governments. Section 7 of the Constitution requires that local governments must be democratically elected. And as you have pointed out, across several states, you find caretaker committees. And what is being proposed now is that where you have non-democratic structures in any local government in any state, that state will, the local governments in that state will not be recognized, and money that would accrue to the local governments from the federation account, pursuant to Section 162 of the Constitution, will not be given to those local governments. Because at the end of the day, part of these caretaker committees is also about control. It's also about control of finances. Because then the tenure of those structures is then at the behest of the actors at the state level. And so there is a proposal to make sure that if you do not have democratically elected local government councils, and what you have then are caretaker committees, interim management committees, or some other undemocratic structures, they will not be recognized, and they will not also have the benefit of funding from the federation account. And you have raised the issue of the state independent electoral commissions. It is a tragedy that in many states, although not all states, if you take Kaduna State, for instance, that's not the case. But in most states, you find that where elections are conducted by the State Independent Electoral Commission, the ruling party invariably determines to a large extent the outcome. But that has led some people to then say, elections in respect of local government should now be conducted by the Independent National Electoral Commission. That then becomes problematic because, yes, there is a problem. And as we discussed in terms of the debate about policing, the solution is not to now say, let's centralize the conduct of local government elections. No, it is to say, why do we have this kind of outcome when an election is conducted by a state independent electoral commission? And what are the mechanisms that we need to put in place in order to ensure that these state independent electoral commissions are not just independent on paper, but are truly independent, so that they give us the kind of elections that meet the expectations of Nigerians? So that's part of the debate. When we have a problem, the solution is not to just say, let's federalize or centralize this. It is to say, why do we have this problem? What do we need to do in order to address that challenge? And that is part of the conversation that needs to take place.
Okay, thank you, Prof. Ezenwa, wouldn't that increase the burden on the federal INEC, and that's one. And I want us to talk about the arguments about separating the office of the Attorney General of the Federation and the Minister of Justice. What is the rationale behind that?
Well, first is what level, excuse me, what level of investment have we made into improving federal structures? What support systems are available for them? Take INEC, for instance. Donor investment, civil society engagement has seen some level of improvement. Who does that for the state structures? Who does that for the subnationals? Okay, so yes, we want something from them, but we're not giving as much. So the challenge is not them. The challenge is that there is not serious interest in subnational conversations, subnational institutions. Okay, if there is a conversation around budget, federal budget, all of us we will bring it up as an issue. The federal budget, the budget when it is released, things. Now, local governments have budget. Educated people who live in those environments don't even bother about the budget of those local governments. Oh, they sit down, simply say, oh, the governors have ambushed the local government resources. But you cannot spend money in the local government without appropriation. And appropriation is that intention. What does the local government intend to do within a year? The people who live in that local government do not need an invitation. They should come by themselves and say, you spend budget. Where is it? We are not seeing it. So our aloofness, our disinterestedness in subnational issues is what we always come and then bring it out as if the federal is so super. INEC conducted the local government FCT elections. The challenges, except for allocation of votes, which you see in subnational elections, every other challenge you see also played out in terms of technological glitches, in terms of early non-early deployment of materials. There are institutional problems. Well, we don't engage them. That's my challenge. So we can be debating democratically elected local government. So almost all the states have decided to conduct local government elections. But what kind of, you want us to conduct elections? No problem. So they appoint the SEC. The SEC announces a result and say, if you want the details, come to our office. I've seen that.
But Ezenwa, what you are saying is noted, but it doesn't require a constitutional provision to awaken civil society at a subnational level, to awaken the citizens to their rights. It doesn't require a constitutional amendment, does it?
That's what I'm saying, that I'm just making the point that I am happy. I want it to be a law. I want it to be a law that you must conduct local government elections democratically.
With consequences if you don't.
With consequences if you don't, which is what we are playing. Yes. Executive order does not resolve it. So constitutional amendment is the thing. The issue of legislative fiscal this thing for local governments and judiciary and all that has to be a law. I'm for that. But I have gone beyond that to say, what investments are we making? All of us, civil society, media, donor, citizens generally, in terms of raising subnational conversations and put it on the front burner. These elections, the local government elections are the theater where our people should learn democracy through participation. So, but when we don't have opportunity to even express that, where people sit down and give themselves 99% of the votes cast in an election, it's you can't say you are learning anything from there.
Well, Ezenwa, the other point, I don't know whether you want to respond to it. Professor Dakas was talking about some of the arguments that they have heard about why we shouldn't have state police, which also deals with the mechanics of resolving some of the knotty issues around state police. For instance, that state governments have challenges paying their workforce. Now you have a state police and you arm the state police and you're unable to pay them. These guys will be on the street. How would you respond to this? On the one hand, State governments are already making investments to the running of the federal police in their state, or the state commands in their state, which is under the federal authorities. Secondly, a number of states have created quasi-police organizations, even though they don't deal with some of the issues that we talk about. A number of traffic. Last month, for instance, in Lagos, Hisba in Kano, there are complaints about they are not being paid, but it will be a desire for those states that want to have their own police to have their police. And who says, is every policeman in Nigeria necessarily armed? And for those who are armed, how do you explain the Roger phenomenon?
So for me, is oversight. I've always been more interested in oversight. If citizens don't oversight anything, you would. Why wouldn't a governor pay salaries? Why? What's the argument? The argument for state creation, the argument, like we are doing, the argument that people put out when they want states created is that they can take care of themselves. Mm-hmm. They tell you, reel out all the mineral resources that are in their states and all the opportunities. All that is done. So as soon as you are elected, you abandon those things because there is no oversight, no engagement by citizens in terms of Zamfara, Arabian gum, all kinds of things, phosphate in Sokoto, all of those things. Nobody is interested. The federal government is not saying you can't generate those resources and pay your people. So is a function more of abandonment, citizen abandonment of their relationship with the state that plays out as the, if you permit my use of that word, the irresponsibility that we see, where people paying salary becomes an achievement. An achievement. There is something that is worrying about that. But you know that at the end of the day, security vote there is no issue where the security vote is not, we don't get it. It must be paid. And you hear the conflict that is happening in some states about, I didn't take my security vote, I should now be paid, all of those issues. So for me, more practically speaking, is to say, we need to be serious. The states that have already put up last man and the rest of them, they make them, what do you call it? They generate somehow they generate funds for them. The internal generated revenue. If the holes are plugged, the states should be able to take care of those issues. But the bigger fear is not whether somebody is armed or not. Like I said, it's about control. It's about that whole desirist attitude that, I'm in charge here, lock up people without due process, forget them in jail, you are controlling the judiciary, you are controlling the police, you are controlling the legislature. That will be absolute power. And we hear that absolute power corrupts absolutely. For the Attorney General issue, there is already positions on that. The Attorney General and Minister of Justice is not working for the president. He should work for the country. If you separate that office, one will be Minister of Justice, who is, the president's person. Then the Attorney General of the Federation will be Attorney General of the Federation, Officer of the Federation. But what we have now is a mix of those two, and the conflict that we see in that is that there is a beholden. Somebody is more beholden to the appointer than to the Nigerian people who should serve, and that is the conflict that we're seeing.
And how the Attorney General will be appointed versus a minister or a commissioner of justice, because presumably what plays out at the federal level should also play out at the state level. And incidentally, Professor Dakas himself is a former Attorney General and Commissioner for Justice. Professor Dakas, is it a linear perception to assume that mere separation of the two offices might cure the political interference that is often reported with regard to the roles of AG and Minister or Commissioner for Justice?
Very much. As a former Attorney General of Plateau State, I actually was Attorney General. I left about 16 years ago. I have my personal views about this, but let me say that there is a proposal in the context of this constitutional amendment to separate the two offices. It has, at the level of the committee, now keep in mind that the National Assembly is actually still at the committee level. It has passed the committee level. It hopefully will be late before each chamber of the National Assembly in plenary, sometimes next week, because the idea is that before the end of the month, this gets transmitted to the states. So there is that proposal on the table to separate the Office of Attorney General from the Office of Minister or Commissioner. Now, it is interesting that a similar proposal actually passed both chambers of the National Assembly, was able to garner the required 2/3 concurrence from the states, and when this went to the president for presidential assent, this was one of the proposals that was rejected by the Jonathan administration, I think, at the time. But those who have pushed for this have predicated their argument on the need to ensure that that office is professionalized. It reduces partisanship and the risk of abuse. And I think those arguments are important. But I think it is also important to underscore the fact that the man makes the office in many cases. And as you rightly pointed out, you may have a situation where you separate the two offices. If you don't have individuals that have integrity and capacity, at the end of the day, you will not even achieve the results. So the recruitment process, the quality of the individuals that we recruit, the security of tenure, the independence of these individuals is also important. And under
Professor Dakas, we're running out of time. You know, there's never enough time to, to talk about and discuss constitutional review in Nigeria and matters arising. I'm sure we'll get to that some other time. Professor Dakas, can you hear me? Well, Professor Dakas C. Dakas, Senior Advocate of Nigeria and consultant to the National Assembly Constitutional Review Committee. He's a former Attorney General and Commissioner for Justice, Plateau State, and also former Dean of Law, University of Jos. And also in our studio, Ezowan Wago, Chairman, Partners for Electoral Reforms, and co-convener, Say No Campaign to Nigeria. Gentlemen, thank you so much for your contribution on this show and your contribution to the conversation. It's been a pleasure having you.
Thank you.
We'll take our sports update now. For today, join us tomorrow for another edition. I am Juma Yusuf.
And I'm Kingsley Osadola. Do have a great day ahead, and of course, a lovely week too.